behind you, we have Joe Jones, who is the head of international data transfer regimes at the DCMS, which is the lead department in the UK on data protection policy. So I think no better person to help us wade through those possible spanners, if you wade through spanners, but anyway. And then Peter Wright, who's managing director of Solicitor at Digital Law UK, I think is the name of the law firm, and he's also the chair of the GDPR working group of the Law Society of England and Wales. So again, a really great expert for us today in this session. So without further ado, Peter, I'm going to hand over to you to give us a bit of the general context. Thank you.
Thank you very much, Elizabeth, and hello, everyone. And indeed, I promised to give you a sort of 5-minute primer on exactly what we're talking about here when it comes to adequacy. What does it mean? And in short, we're talking about the flow of personal data from the European Union to the UK. So we're talking about data stored on servers, data on systems within the EU member states to the United Kingdom, subsequent to the UK having left the European Union, and of course that now being confirmed with the UK-EU trade deal that was agreed just hours before Christmas, indeed. And when it comes to adequacy, this issue is still outstanding. So while there was sort of the celebrations before Christmas that a deal had been agreed, adequacy, i.e. allowing the flow of data from Europe to the UK, was not agreed as part of that package. And indeed, the transition period that the UK had been in since it left the European Union in January of 2020 has been extended for an additional 4 months, allowing for an adequacy decision to be reached. And the principle here is that when you are within the European Union, when you're inside the single market, it is in effect a free market in terms of data. So data can move around between all the EU member states unimpeded, unimpinged. But once you're outside the European Union, strictly under GDPR and under data protection law, you have to allow that data can only be allowed to leave the EU if there is what is called an adequacy decision, which is, in short, the European Commission saying, yes, the laws in that country and the standards are adequate in comparison with EU law to allow for the flow of data. And that then means that that data can easily pass from Europe to the UK. Practical implications of this, of course, is that huge amounts of infrastructure are, of course, based in the European Union when it comes to the digital systems we use every day. So, for example, an awful lot of the systems, the servers that AWS, Amazon use are located in Ireland, as are Microsoft servers, Apple, etc. There's a huge amount of systems that we use every day that are located in the EU. And without an adequacy decision, you then have to fall back on other safeguards, things like standard contractual clauses, which are fairly lengthy terms that have to be included in any data transfer agreement that would cover the transfer of data from the EU to the UK, as well as things like binding corporate rules and codes of conduct. So there are ways of being able to get data to be exchanged from the EU to the UK, but it's certainly not as straightforward as an adequacy decision would afford. But we'll be looking at the ins and outs in terms of that adequacy decision today. And I think it's just worth bearing in mind that adequacy decisions can be made very, very quickly, as was the case when it came to the EU granting them to Japan and Canada when they had their free trade deals agreed. In comparison, though, New Zealand, it took 6 years for them to get an adequacy decision. So it's very much in that context that we are now hoping and looking at the prospects of an adequacy decision for the UK in the hopefully within the fairly immediate future.
Thank you. Joe, perhaps over to you then, if you'd like to follow up.
Great, yes, very happy to, and thank you very much for having me. Just picking up on the last point made there, hopefully we won't be looking too hard or for much longer. And the UK government usually does not comment on leaks, but let me say, and let me reassure everyone here that we understand that the EU will publish adequacy decisions for the UK very soon. Those adequacy decisions will be positive. They'll conclude that the UK is adequate. And that will trigger an EU procedure to adopt those decisions and make them law. The mere publication of the Commission's finding does not mean the UK is legally adequate at that moment in time. All that does is it triggers an EU procedure. That procedure will involve the group of EU data protection regulators, the EDPB, issuing an opinion on the adequacy findings. MEPs, of course, in the European Parliament can debate it, they can issue resolutions and their own opinions, and then it will fall to the member states to approve it. Now, I was saying decisions because there are two adequacy decisions we're talking about here. One under the GDPR for general processing, and the other for law enforcement data sharing. And this will be the first time that the EU has actually concluded a law enforcement adequacy decision. It will be the quickest they've concluded a GDPR decision. And it certainly is our hope and expectation that the procedural phase will be wrapped up swiftly and successfully. It's always been the UK government's position that there's no reason why the UK should not be adequate. The Commission has never had a more straightforward, more aligned country to assess. And in fact, this is the only country that they've assessed that is not expanding the realm of data transfers. This adequacy decision will just be confirming what existed on the 30th of December last year. That data could flow freely from the EU to the UK. Of course, it's important that that decision evidences why data can flow freely to the UK. It evidences the UK's high data protection standards. And that's particularly important because this has become an increasingly litigious area. And so we've got to ensure that the decisions provide businesses, organisations and citizens with confidence and certainty that these decisions are going to stand up to scrutiny and are not going to be sort of struck down by subsequent cases. So we've made great progress so far. It will be terrific for organisations, I'm sure, to have that publication that says the UK is going to be adequate. We're not done yet. I'd encourage organisations to keep up with the momentum, to keep encouraging EU stakeholders to get this done swiftly and successfully.
Thank you. So I think a very clear suggestion that businesses continue to support the process. Can we just stick with that process just for a minute? Obviously, all these things need to happen. I think that neither the Parliament or the EDPB can stop it, but they might be able to delay it. So what if we get to the cliff edge and the opinion hasn't been given, or Parliament hasn't responded, or the member states haven't managed to approve it?
Yeah, I'm happy to go first, and then maybe it's probably better if Peter covers what organisations can do in the event that we are in that scenario. So obviously, first of all, we don't want to be in that scenario. It's in nobody's interests that we are even talking about a cliff edge or preparing for a cliff edge. It's in the UK's interests, the EU's interests, businesses' interests that publication triggers this process, which should essentially be a done deal, right? No one can block it. Of course, it should be scrutinised. There should be due process, but we should be moving towards greater certainty in this area. Right, so that's the first point. We did agree with the EU this bridging period, and it can go up to 6 months, so it can be in place until the end of June. And that's a sort of, it allows continued flows of EU transfers to the UK. And it's certainly our expectation that we should be done with the process by the end of June, if not much before then. But we do have that sort of, in a sense, a transition period again, or a safety net, a buffer zone, however it's described, until we get this done. But maybe I'll pause there and see, Peter, if you want to.
Yeah, Peter, are you as confident? And actually, maybe picking up, but we have a question from Rita Giannini, who asks whether you're as confident for the law enforcement decision as you are for the GDPR one. So a very good follow-up question there. Thank you, Rita.
I think I'm, hopeful that we will get an adequacy decision, but I would just apply a little bit of caution to this. One is that the adequacy decision, when it comes through, will be then subject to review after a period of 4 years. And that's just a standard mechanism whereby we'll just review data flows, look at data, look at evidence, decide how the relationship is progressing. But also, it is still something that could potentially be challenged in the Court of Justice of the EU, as has happened when it comes to data transfers from the EU to the United States, which have been successfully challenged twice by Max Schrems. So just because we get the adequacy decision does not mean that it is there forever. It can be subject to challenge. I think the other thing to bear in mind is that we hope that this will follow, but as we've seen since the deal was agreed, indeed, an awful lot seems to have happened in the 6 weeks, and it seems a very long 6 weeks since the celebrations between Brussels and London when a deal was agreed. We've had everything from the sudden sort of threat and triggering of Article 16 to some quite significant rhetoric between London and Brussels. And I would hope that that would not have any influence on a likely adequacy decision. But I think it's always important to hope for the best and plan for the worst. So I'd be minded to still depending on the size of my organisation, if I'm heavily reliant on the flow of data from Europe for my organisation's continued operation, I might look at the data transfer agreements that I've got in place and make sure I've got standard contractual clauses in place on those deals, so that if in the future there happened to be any question or that adequacy decision was to be brought into question in any way, you could then rely on knowing that your organisation is insulated regardless, because you've got those standard contractual clauses to fall back on, which at this moment in time are the mechanism of choice in the absence of an adequacy decision, to say in the event of data transfers between third parties, so a contractual relationship, say between your organisation and the subcontractor, that will be able to continue based on reliance on those standard contractual clauses. If, on the other hand, you're a multinational corporation, getting some binding corporate rules approved by a regulator, by one of the European data protection regulators, will then ensure that data can move around your organisation, even if you've got offices in Asia, the Middle East, Europe, the United States, and the UK. If you've got those binding corporate rules in place, then they will mean that data can freely move around either your company or your group of companies quite freely.
So, Peter, that kind of begs the question: if you've got one of those two things in place, why do we need adequacy at all?
Well, indeed, a lot of organisations already have those mechanisms in place, but equally there are an awful lot that don't. And given that for the last 40 years we've been able to exchange data easily with Europe without having those mechanisms in place, then many organisations do not have them in place, and at the moment have not been able to look at doing that over the past couple of months either. So it is a significant exercise to get the correct standard contractual clauses appended to a data transfer agreement. If it's a big organisation, getting that agreement through, signed off through corporate governance and getting it agreed between parties can be a significant process. And also getting binding corporate rules drafted, agreed, embedded across an organisation, as well as signed off by a data protection regulator, that takes many months, if not years, to bring to fruition. So hence we've always relied by and large on adequacy. And those other mechanisms are something that only a handful really of organisations, a very small proportion of them, will have put in place in the intervening period.
Yeah, I think there's also an important point there on the sort of indirect benefits of adequacy as well. And there's obviously direct sort of compliance costs that are incurred, but adequacy really is, amongst other things, it's a vote of confidence in the regulatory regime of another country. And that provides certainty, it does provide some stability. It provides a single point of reference if you want to know what the laws are in another country. Now, this was particularly true for Japan. Now, we had heard from stakeholders, UK organisations, it's difficult to understand what the data protection laws are like in Japan. There are language issues, there are cultural issues. We don't really know how this applies or how this fits. Now, the adequacy decision, and credit to the Commission here, really set out what exactly it is organisations need to be thinking about when they do business in Japan as concerns data protection. So it is first and foremost a data transfer mechanism. Secondly, and importantly, it does provide regulatory confidence and hopefully stability. And there is a reason why, despite Schrems 1 and despite Schrems 2, the EU and the US are negotiating a successor to the Privacy Shield. Lots of organizations use the SCCs and BCRs for transfers to the United States, but it's that adequacy decision that provides greater confidence for the market.
Schrems 3 then.
Which hopefully won't go the same way as Schrems 1 and 2, if there is Schrems 3. But just quickly to respond to the question on law enforcement, yes, we are absolutely confident in that as we are in the GDPR decision. It's been very interesting going for a law enforcement adequacy decision, being the first country to do that, because it has socialized and brought to the surface all of the non-commercial, non-trade reasons why data transfers are important. So the fight against crime, or international cooperation, keeping our borders safe and secure. We do often think about data transfers as tech issues or digital company issues, and it goes way beyond that. And it's been very interesting to see these arguments come to the surface. So those are the, sit outside the technical assessment of it all. But another reason why this is very important.
Peter, do you want to jump in? Schrems 3?
How long have you got? So that's a very good point, that we've had, of course, these twice now, adequacy decisions between Europe and the US have been struck down by the Court of Justice of the EU as a result of litigation brought by Max Schrems, who started out life as an Austrian law student who made a...
Bloody lawyers, huh? Speaking as the next one.
I mean, what's incredible is that he was just a law student, but did a subject access request against Facebook. Wasn't happy with the transparency provided by Facebook in respect of his data being transferred to the US and being processed there. And as a result of that decision, that struck down the safe harbour arrangement that had run for 15 years between the EU and the US in 2015. And then he brought another action, now running his own not-for-profit called, I think it's called None of Your Business. NOYB is his not-for-profit agency, and they successfully then struck down the EU-US Privacy Shield last summer. And indeed, as Joe quite rightly says, there's now the negotiations are in place between Brussels and Washington on a successor arrangement. But I think it's worth highlighting the reasons why in that case last year in particular was successful was because of the surveillance practices in the United States, whereby the way that the data of foreign nationals in particular can be subject to surveillance meant that there were concerns that even if organizations had signed up to the terms of the Privacy Shield and were abiding by all of those terms and requirements, there was still the risk that their data could be not secure and subject to bulk surveillance. And historically, there are similar concerns with regards to the UK's data security arrangements. So in particular, there was the Investigatory Powers Act of 2016, which gives the security agencies, and I make the point here that these are powers given to the security agencies to keep us safe in the face of the ongoing security threats. But these allowed things like bulk surveillance of communications by the security services, and that practice may be incompatible with adequacy in the long run. So if there was going to be a challenge by, say, potentially Mr. Schrems, that would be the grounds that he would seek to use, would be to say, well, look, the UK's practices here are in line with what was found to be problematic in the US, and therefore that will be the basis of a challenge. Though he's actually already said that he personally, his organisation, won't be making a challenge to any UK adequacy decision, but he said regrettably, he said that's because he felt it would be such a straightforward challenge to the Court of Justice, and so with such high prospects of success, he felt it really wasn't something that he would devote attention to. So he's sort of almost giving the challenge and leaving it to someone else to pick up the gauntlet there, potentially.
Wow. Okay. Sobering thoughts then. And I think maybe whilst we're talking about the present, let's wind forward just a little bit to ask the question that I'm sure others will be thinking, which is what happens if and when the UK GDPR diverges from the EU GDPR? What do we think will happen then?
So I can take this one. So look, the UK has left the EU. It has sovereign ability to determine and set its own rules on data protection. Indeed, we published a national data strategy in the autumn last year. We consulted the public on how should the UK best set and deliver its policy on data issues, not just data protection, but more broader than that, data security, data localization. Now, we already have implemented the GDPR in UK law. We have the UK Data Protection Act. We had Data Protection Act before the EU directive on data protection in '95. So we have this long-standing commitment to high standards of data protection. But it is right and proper that now that the UK is independent, that we look at those laws and reflect on whether they are fit for purpose, whether they work for a single state, whether they reflect our business community, whether they reflect our cultural understanding of data protection and privacy. I mean, privacy is fundamentally a very cultural issue. How we think about it in Europe and in the UK is quite different to how people think about it in other countries. I was on a very interesting panel a couple of months ago with folks in Kenya. And it's interesting because we talk about sensitive personal data. Now that is very contextual. So in Kenya, how many children you have is sensitive personal data because that is important. Similarly, what tribe you belong to. And here we have our own understanding of those issues. So it's right and proper that we reflect on how our regime works. Now, divergence is always assumed to mean lower standards. Now, if the UK in the future hypothetically changes its law, that does not necessarily mean it's lower standards. If the UK were to say, pick a country for adequacy, for a UK adequacy target that the EU has not done yet, does not mean we've lowered our standards to do that. It just means we've pursued an opportunity that exists in compliance with our law, and by the way, our law is the same as the EU's law. As Peter says, the EU has built in a review mechanism to the adequacy decision for the UK. It has that for all of its adequacy decisions. So it will have to keep monitoring whether the UK remains to be adequate, whether there's anything significant that happens in the UK that calls them to revisit that finding. And in 4 years' time, they'll do a periodic review of the UK. And I'm sure we'll be as adequate then as we are now, which is adequate.
So it's qualitative, in fact. Peter, I think you want to jump in, do you?
Yeah, it was just actually to make the point that I absolutely agree with everything Joe's just said there, and that I think we also have to bear in mind that in terms of the sort of UK status, I think we've had a highly effective regulator in the shape of the ICO. When we look at the quality of the enforcement, we've of course seen those high-profile fines for British Airways and Marriott. Originally, when they were announced, they were sort of in the hundreds of millions of pounds. That's been reduced down when those fines were finally confirmed last year, I think largely because of COVID and the economic situation. But nonetheless, there's been continuing, ongoing, proactive enforcement of GDPR by the ICO on a very pragmatic basis. When you look at the enforcement decisions, it's where there has been found to be real egregious issues with regards to demonstrating compliance and complying with the law as it is. And also, as Joe says, we've got a strong history of not just taking on board EU law around data protection, but creating the law around data protection, going back many decades. And I think it's been striking for me when I've been to events like the annual Computers, Privacy and Data Protection Conference in Brussels, which I've been to. And an awful lot of the speakers there are British, because they were seen as leaders and experts in the fields around things like data protection and cybersecurity, and the regulator has reflected that. So when we're looking at standards, it's very difficult to find, I think, a country with standards that are any better than those that we have in the UK in terms of the quality of our enforcement. Also, a really good point that Joe makes with regards to how data protection and privacy is compared, even across the EU. I think there's big social differences there. I've spoken at a conference in Poland for the last couple of years, largely to students and young lawyers, but it's interesting when you look that within living memory in Poland, they have had, of course, a government that did huge amounts of bulk surveillance against its people, and therefore people are a lot more wary of how and when personal data is collected, and a lot more wary of providing it anyway, because, of course, they have experience of how that can be used against them, whereas in the West we've not really had that, certainly not within living memory, and therefore we tend to have a slightly different approach to that, particularly when I speak to a lot of young people who are like, well, look, I'm fine providing huge amounts of personal data so I can get to use this app and share this information and take part in the digital economy. So there are massive changes in view just across Europe, let alone, as Joe says, when you go further afield culturally.
Yeah, and I don't mean to antagonize our EU counterparts, but the point about no two countries being the same is very much true in the EU context as well. So notwithstanding the fact that there is the GDPR, there is the European Convention on Human Rights, there's the Charter on Fundamental Rights, there are important differences at a member state level. National security is one, but also the role and the effectiveness of the regulator is another. And I think, one thing that the UK is very keen to do is actually to embrace those differences, recognize that those differences are born out of these cultural, it's born out of a cultural context and background and history, and try and find ways of making these connection points on data transfers, despite the differences. A good example was with Japan, very different cultural background, approach to privacy, but nonetheless adequate. As you said, Elizabeth, it's about the quality of the protection rather than the form and the means of the protection.
Before we kind of move, you can see loads of questions coming in now, but before we move off this, just going back to a question that Christoph asked about surveillance, because I think it's it's relevant in terms of MEPs can make quite a lot of noise about this, and Sophie Invel actually made a comment exactly about this, that it would be an obstacle. I think maybe that points to the impending court case that's likely to to ensue, but just wondered if you had some thoughts on that.
Yes, unsurprisingly, my thoughts are as follows. Look, I think the UK really does have a world-leading investigatory powers regime, and it's world-leading in a few respects. One, it's very transparent. You can Google it, you can find it, you can see for yourself the rules that apply to how the government accesses personal data of citizens. You can see the purposes why it does that. You can see the limitations that apply, and you can see the rights that you have and the redress that you can get if you're unhappy with that. Now, that is world leading. That is not true of many countries around the world. Dare I say, I don't think it's true of some countries in the EU. Now, so we're very confident about that. We're also confident that our law strikes the right balance between the right to privacy, which is not an absolute right, though it is incredibly important, and the responsibility of government to keep citizens safe, not just citizens in this country, in the UK, but also to cooperate with governments around the world to combat international crime and terrorism. And so we strongly believe our law strikes that balance. Of course, there have been past court cases relating to historic legislation that has struck down that legislation, and we've learnt from that case law how to set up a regime that can withstand that scrutiny and can stand up to it. So we'd be very confident if there if there were a Schrems 3, that it would not go the same way as a Schrems 1 and a Schrems 2 if it were for the UK. But you would expect me to say something like that, probably.
Peter, do you have the same confidence?
On the fair and equitable basis that Joe's just outlined, absolutely, you would absolutely have full confidence. I think my concern would be, though, that sometimes certain decisions aren't necessarily entirely based on that. Sometimes unfortunately, political issues can come into it. And I mean, there was a decision of the CJEU last autumn that looked at the UK's security regime and this sort of surveillance legislation, and was very critical of it. And I almost looked and thought, if you were looking at a reason not to have an adequacy decision, that's almost given you the reason, good enough cover to withhold it. You could point to that judgment and say, oh, well, clearly the CJU has found these issues, and therefore, we're either going to withhold it, or we're going to carry out further investigation, or we have these questions to be answered before we grant an adequacy decision. I mean, as Joe just said, if you were looking at the fact that we are very open and transparent and make it very clear where the rights of citizens are affected by the security legislation, I think this is very clear. There are a number of countries where those security powers are not clear and transparent, but because we have the rule of law in the UK, and we're very open in terms of saying, look, these are the specific laws that govern what security services can and can't do, and what they're able to, how they're able to exercise those powers, then it's very open, and you can use those to see how the system operates. But you would hope that if in a world of fair and equitable decisions, you wouldn't think that would get in the way of a adequacy decision. But as we've seen, sometimes events have moved very quickly in the last year in the world that we now find ourselves in. It's become, I think we've all found the danger of making any long-term predictions in a number of aspects. And this is where I'd say there is a sort of danger of seeing too far into the distance. So I think my message today is, let's absolutely hope for an adequacy decision, and absolutely hope that then lasts, and it's just subject to the review that Joe mentioned. But if I wanted to make sure my organisation was on a really strong footing, I'd also want to make sure that I've got those standard contractual clauses in place and binding corporate rules potentially as a backstop, just to make sure that if there are any rumblings or problems in the future, you can at least think, well, at least, as a belt and braces approach, we have other things to rely on as well.
Yeah. I think sticking with the divergence or otherwise of the UK and the EU on data privacy, and notwithstanding, Joe, what you said about chances are, it wouldn't be lower, it would just be different quality rather than anything else. Let's look at Hansa Emzivat's question about unfair competition. Do we think that, presumably that's where the review would kick in, but he's suggesting some other potential possibilities around payment mechanisms or CBAM. Do you have any thoughts on that?
So I'm not an expert on competition law, but I do think there's an interesting point in there, which is countries can set up their data protection laws in the way that's most advantageous for their own interests, including the organizations in that country. And so, of course, it could be possible that in years to come, the Commission or member states view the UK's regime as competing with the EU's. I don't know I'm not an expert on the recourse that they could have if they take that view, but that happens, and I think the Prime Minister's view, once we'd agreed to the trade deal with the EU, is that it's not going to be a bad thing for Europe to have on its border, as it were, a more agile partner, not working against it, but pushing it and challenging it to think a bit more creatively and flexibly.
Okay, Peter, do you want to come in, or should we take another question?
No, I'd entirely agree with that, so happy to move to another question.
Okay, well, I think just quickly, there are a couple of questions on e-privacy. I think Silke Dalton's question probably relates to e-privacy, and Eric Otto's also asked a question about e-privacy. Of course, as we know, the UK won't implement eprivacy. That's if there is an eprivacy deal. And so, you know, what do we think will happen there? How far do we think it will differ? Will it in itself also affect data adequacy in the future?
So we've got to see what's agreed in the EU first, if something is agreed. But adequacy, in terms of the impact on adequacy, adequacy has got to be a snapshot technical assessment of a country's laws and practices. It shouldn't, and it can't ever really be an assessment of hypothetical future changes or divergence. You know, and credit to the Commission for doing it this way. They look at our laws as they exist and the protections we provide in the here and now, and they compare that to the protections that exist in the here and now in Europe. So I think it's going to be impossibly challenging to do that kind of comparison exercise based on a eprivacy regulation that doesn't yet exist, and that, again, something, you know, what the UK may or may not do if that regulation exists.
Peter, would you like to add to that?
Yeah, and I think it's also important to bear in mind that the eprivacy regulation, the draft eprivacy regulation, looks at communication systems as a whole. So it's designed to look at things like instant messaging, so systems like WhatsApp or BlackBerry Enterprise Messenger, LinkedIn Messenger, Facebook Messenger, all these sorts of things that are now allowing us to do communications. And in fairness, things we've relied on hugely over the course of the last 12 months as we've shifted to more remote ways of working. But it also, because it's looking at communications as a whole, that means it's going outside the remit of data protection. It's important to bear in mind, I think, that when we're looking at adequacy, we're talking about personal data flows, information that identifies an individual, whereas eprivacy can look far more broadly than that. Its remit is much broader than just data protection. It could be looking at anything that's in terms of the privacy of electronic communication. So not just personal data, confidential, commercial data, a much broader remit. And in terms of how that may therefore work in future, I think it's really important, as Joe says, that, I mean, eprivacy's gestation has been difficult, to say the least. It was supposed to become law along with GDPR. It uses the same enforcement matrix, but the idea was that GDPR and eprivacy would have both become law across the European Union at the same time. Instead, GDPR has now been enforced for a number of years, since 2018, whereas eprivacy, there was an announcement last week that we finally have some draft text, but we have been here before. There has been a draft eprivacy regulation produced before, and then that was subject to such a lot of lobbying from member states and from other organisations, private companies who would be subject to the regulation, meant that it couldn't be agreed, and had to go into a trilogue for a very long period of time between the Commission, the Council and the Parliament. So I think the jury's still sort of out, really, in terms of does the proposal as published last week, will that even become law? And if it does, of course, there'll then be a period of several years, like with GDPR, a sort of transition to allow it to become law rather than it coming in overnight. So there's an awful lot of maybes associated with the introduction of that eprivacy regulation across the European Union.
So perhaps just before we move to kind of third country transfer flows from the UK, perhaps, Peter, you could talk to us a little bit about what system you think will be in, what the system will be, the infrastructure in place. We know there's going to be this review, mandatory review. What are the joint committees and the various infrastructure that will be set up or will be used between the UK and the EU to oversee adequacy? Will there be any changes, or is it just the system as the moment?
So my understanding is that there is the European Data Protection Board, which is the board which is made up of representatives of all of the different national regulators. The ICO was a member of that, but has now left, of course, with the UK leaving the European Union. I think they're still has in communication with them, but we're not a member is the key point there.
Exactly.
Now that body can scrutinise the decision. It can't stop the decision in terms of adequacy, but it will look at it. It'll look at the reasons behind it, and I'm sure it may end up providing information and evidence back to the Commission. But when it comes to adequacy, that is strictly a decision of the European Commission in Brussels. my understanding, and I stand to be corrected on this, having not read every single page of the free trade agreement, is that I don't believe there's a joint committee, but Joe may be able to correct me on that if I'm mistaken. And as I understand it, it's very much just that the European Data Protection Board is involved in scrutinising that relationship, but as I say, it's not a decision-making element to it. So I believe that's the sort of the ongoing situation, and therefore the main mechanism by which this decision of the Commission can be challenged becomes the Court of Justice of the EU.
Joe, can you just confirm that?
Yes.
Are you able to?
So the EDPB can't veto it. They can scrutinise it. We've agreed a joint committee process for the bridging period for data flows, not for beyond. Beyond, we've got this review period baked in, and there is dispute resolution. There's an independent dispute resolution mechanism built into the trade agreement itself, but adequacy sits outside the trade agreement. So once we get an adequacy decision from the EU, it wouldn't be part of the dispute resolution mechanisms that have been agreed in the trade deal.
Right, so it will still solely sit with the Commission, with no kind of link, no formal link with their counterparts, although informally I have no doubt there will be.
Yeah, it sits with the Commission. It will of course sit with the Court of Justice if it's put before them, and it does sit with the data protection regulators in their capacity as, you know, monitoring compliance with data protection and advising organisations.
Great, okay. Shall we move quickly then? We've only got another just under 15 minutes, I think. Shall we move quickly to, well, and importantly, to how will this impact UK transfers, data transfers to third countries? Maybe you kick off, Joe.
Yes, great. So look, one of the important things to note that isn't really talked about that much actually, is that the UK has already recognised the adequacy of the EU. We've already introduced legislation that's come into effect that says for transfers of data from the UK to the EU member states and the additional 3 EEA states, those are adequate data flows. We've also recognised the adequacy of the 12 existing countries that the EU has said is adequate, plus Gibraltar. So that's who the UK has said is adequate now. Of course, we want that list to grow. There's a lot of opportunity out there in the world. This is not, you know, things have moved along. You know, 5 years ago, we didn't have the same level of sophistication across the world on data privacy regulation. I saw a report the other day that said that over 140, 150 countries have a form of data protection law. That's not me saying that they're all adequate, but it does mean there's a lot of opportunity out there. And this is not an esoteric regulatory point. I mean, these things, you know, data adequacy, data transfers, they matter. They matter to how we live our lives, how we make our choices, how we connect with our communities and our families and loved ones, and they matter to how we do business, so supply chains, delivering services. So it's not, you know, I hope it's not trite for me to say it's incredibly important that governments, regulators look to do more international work here to improve the interconnectivity on these issues. I certainly welcome the negotiations that the EU is in with the United States, and we hope that comes to a positive, durable conclusion for a successor to the Privacy Shield. I think there's loads of opportunities out there internationally, and it's great to see. Some countries are doing adequacy themselves. You know, we often think about adequacy as something just the EU does. Lots of countries are now doing it themselves. So look, lots of opportunity out there. I don't want to say too much about specific countries and prejudice sort of future decision making there, but you know, even the EU and the Commission has published papers. They've said things about some of these countries. They're doing a lot of work out in the field, sort of developing capacity and capabilities, working with partners, and I think that's a good thing.
Peter, I'm sure you're not quite so shy in coming forward with some thoughts about particular countries.
Yeah, I mean, I think the important thing to bear in mind is as Joe says, there's some great opportunities out there, and we've seen that from a standing start with no international trade capability, we now have the UK Department of International Trade that's raced to get in place as many rollover deals replicating the arrangements that the EU had with countries overseas, so that the UK can have those same benefits or indeed exceed them a little bit in some instances, as we've seen with the trade deal between the UK and Japan. So, as you said, we've now got similar adequacy arrangements with Japan, with Canada, and with those other countries that have been subject to rollover trade deals. But I think it's now a matter of when we're looking forward in terms of where the UK is likely to make an adequacy decision, is look at then the negotiations the Department for International Trade is carrying out. So if they suddenly announce, you know, a trade deal with Australia or New Zealand, well, New Zealand, we already have the adequacy decision, but if for example, Australia or India or another country, we start to see news around that, then I would expect in those instances that adequacy is something that would follow on the back of those sort of arrangements. So that will gradually enlarge the pool of countries that we can say we can exchange personal data with freely without worrying about the standard contractual clauses, binding corporate rules, and other mechanisms that I mentioned earlier.
So, if you were a warrior, what would keep you up at night in relation to data flows to third countries?
Well, sometimes it keeps me up at night and I'm not a warrior. But I think for me, and COVID, I think, has accelerated this, but it's the debate around the interference with the right to privacy that I think is becoming much more acute. And after all, Schrems 1 and Schrems 2, they weren't really about the protections that companies put in place. They're really about the capabilities that governments have. And I think that is where the debate is heading and where it's going. And on the one hand, you have media stories and reports, and people, of course, want governments to keep them safe. People, of course, want to make use of the digital economy and join webinars that are underpinned by data transfers. But on the other hand, the growth and the uptake in data protection, the awareness, our cultural understanding of these issues has never been greater, frankly.
Peter, what keeps you up?
I think for me, as someone who, as managing director at Digital Law, when I'm sort of thinking about the interests of my clients, very often I'm sort of working with them to say, well, let's make sure we've got the belt and braces approach here. You know, if you're wanting to be undertaking trade, e-commerce in different parts of the world, then making sure that, great if we can rely on adequacy, but if we can't, let's make sure we've got all the other mechanisms that we need to have in place. So it's always a matter of sort of looking at each jurisdiction quite carefully. And for example, so many of them end up working in the US, and of course the US is not a single jurisdiction. It's the best part of 49 different jurisdictions, plus a few districts as well. So it just means that it is never a straightforward exercise. So I'm always worried that potentially, you know, an organization just rushes ahead to start, you know, selling its widgets online in a different country that could have massive implications with regards to transfers that they haven't advised us of. But at the same way, it's because I think this is an issue that, you know, we're tied in talking about this in depth for an hour today, but it's an issue that very often isn't top of mind for many boards and structures in some quite big organizations. And sometimes you could, if they were to look carefully, they might find that their arrangements with regards to the data transfers that they rely on in order to underpin their global operations, they might find that actually they might have a few problems if those arrangements were tested. So that those are the sorts of things that keep me, I suppose, awake at night, along with all the other things that keep us awake at night at the moment, let's put it that way.
I'm just going through, thanks for that, I'm just going through to make sure that we've answered all the questions. I think we have an additional question from Hansa. Thank you. Are you confident about the outcomes on data localization requirements? Maybe it is the area that is going to move the most. Can someone help me with that one? I'm not entirely sure I completely fully understand that one.
Yeah, look, I think data localization is the sort of elephant in the room a lot of the time on these issues. And I've said before, to me, it often comes across as this sort of money under your mattress way of thinking, that you think it's most secure and safest when it's there under your mattress where you can touch and you can feel it. And that way of thinking is not really true in the modern day when it comes to data processing and how we share and use data. And actually, you know, the most secure place to put data is probably not in one country, but in the cloud, or to share it with sophisticated organizations that can apply rigorous safeguards and security to that data. And that's not an advert for large multinationals that provide those services. But I think the debate is quite nuanced, and we are seeing an increase in data localization practices in pursuit of what we think are unnecessary or unjustified purposes and objectives. And I think that will be a real sticking point and debate. And again, it often comes down to culture and understanding of these issues. Some countries think that data localization measures will make your domestic economy boom because you'll be a tech hub and people will set up data centers. But that is quite a short-sighted way of viewing these issues. Actually, we want to be connecting with the global digital economy.
Yeah, that makes a lot of sense. Peter, do you want to add to that, or is that
only to add that indeed, while the cloud is a good, efficient, and cheap way of being able to get your data stored, it still comes down to the fact that that data is going to be in someone's server somewhere or another, and still, even if it's in the cloud, well, where is that data stored? In the event that that primary server goes down, where is its backup? I say these are the sorts of conversations I have with a lot of clients, and sometimes they've thought, oh yes, we're perfectly fine. You know, our server is based here, so we know that we comply. And then when we've actually drilled into it, we found out that if, for example, that server went down, it will be transferred to any one of 6 other servers in multiple different other jurisdictions. So this is where, and I think that's a concern as well. You've got to remember that some sectors are more highly regulated than others. So when I'm looking at clients who are in, say, the financial services sector or in professional services, you know, I think from law firms to accountants, you know, they're very often under an even higher burden in terms of making sure they know exactly where their data is, how safe and secure it is, what the backup terms are, how long it's being retained, all this sort of stuff. And that's where it's a matter of making sure that there are proper safeguards in place that can, A, demonstrate compliance and also show resilience in the event that there is any sudden change. And we've seen a sudden change with Brexit and the UK leaving the EU, and we could see another with future court decisions.
Okay, well, just thank you. I think we've got one quick question, actually, kind of building from what we talked about earlier about the qualitative difference with standard contractual clauses. My colleague Jeremy asks, standard contractual clauses, etc., are quoted as the insurance, and you yourself have said so, Peter, but gave a lot of reasons why they're not the only thing we need to be able to rely on. But he asks, how businesses how are businesses able to or expected to manage the variety of risks involved, given that SCCs, aren't that stable. None of the alternatives seem to be that stable. And he's asking about how we manage the uncertainty that businesses are thrust into.
Well, certainly, I think SCCs aren't necessarily. They sort of may appear to be more vulnerable after the if you look carefully at the Schrems decision last year, but they are in the process of being revised. So currently, the European Commission is consulting on a new set of standard contractual clauses with a view to introducing those. Now, even then, they could be subject to litigation in future, as we've already said, an adequacy decision could be as well. Let's face it, any government decision in the UK or the EU could be subject to litigation. We have to bear that in mind. But I think if we're saying, well, how do organisations comply with both, the law of the United Kingdom at the moment, the law in England and Wales, as well as the law in Europe at the moment, the best way of doing that and the best way of having that extra level of security, I'd say, is making sure you've got those SCCs in place, either the current ones, the ones mandated today as of the 16th of February, or if you then choose to introduce the ones that are approved following that consultation process being finalised. Or, as I say, there are other mechanisms, binding corporate rules, etc.
Yeah.
But I think it's just a matter of looking at your organization's general overall exposure. If you've got data in different servers and facilities all over the world, loads of different jurisdictions, and it's a matter of sort of looking at that risk and thinking, how do we demonstrate actively compliance to regulators in the UK and or in Europe, and making sure that it always comes down to those two crucial words, I find: demonstrating compliance. If you can show you've thought about the risks and you're doing something about it, the regulators will take account of that. The problem is, if there's ever a problem and the regulators say, well, what were you doing about this? And you say, well, nothing really. We've never looked at it in a board. We've never looked at it in a meeting. We've never got any mechanisms in place. That's where you're going to face a problem.
Well, I think that beautifully ends today's session. In the remaining 2 minutes, I'll just say, well, first of all, I think there are two calls to actions. One is make sure you've got your SCCs or your BCRs in place as your insurance policy. One. Two, from Joe, make sure business, we have our voices raised to make sure that the attention on this doesn't diminish, and that we get this through in good time, so that we don't have to face any cliff edges. So two calls to actions for all of us, I think. For me, my call to action to you both is thank you. I think that's been a really, really good discussion, really interesting. So thank you very much for your time and your frankness. To everyone who's still here, we will be doing an event on UK third country transfers later in the year. Let me not forget to plug again the virtual meeting in Strasbourg next month, and the EU-UK relations later this month. All details are on the British Chamber website. Can I thank everybody in the British Chamber for having facilitated this to make it possible, and for the platform to work very well. And I think you can see lots of messages already thanking you for a great session. So thank you very much, and enjoy the rest of your day. Thank you. Bye.
Thank you very much for having us, and thank you to BCC for the event.
Bye. Thank you.